It's 11 o'clock. All right, good morning, everyone. It is June 1st, our first June edition of Bar Talk. And we just have a couple things we wanted to touch on before we invite or introduce our guest. And that is on May 29th, that would have been, of course, Friday, the governor implemented a new Executive Order 55. And what I think she attempts to do there is sort of tie in the executive orders that were due to expire on May 31st. And so what you want to do is take a look at that executive order. You can see how it applies to you. There's a work at home portion. And then, you know, of course, the restaurant portion applies almost county-wide or county specific. So you can take a look at, I essentially look at that as an omnibus type order that continues the protections that were due to expire on May 31st with some caveats. In addition, we wanted to comment that our courthouses are now open from 8 to 4. And although Justice Meade might not know this, but we had the new dean of the law school, Dean Softly, on Thursday, who was reaching back and still making some comments about the judicial branch. And one of those being that we should have expected an 8 to 4 opening because those are the summer hours, the normal summer hours that exist. And that's why in September it's transitioning to 8 to 4:30 because that's when summer hours end. So I thought that was interesting. She still is very interested in the judicial branch. And then we are thankful to Harry McKinney, who is the Civil Service Deputy of Kennebec County, who has been keeping us informed for all the counties across Maine and what they're doing, and pursuant to his information from his components at all the county sheriff's offices, all sheriff's offices are supposed to be in full force for service effective today. So with that, we do have our special guest today, returning Acting Chief Justice Meade. Chief, thank you for joining us today, and we really hope to get a feel for where we might be heading after the stakeholders meetings that you held, and how we might be able to still help in that endeavor. And I will let you know that we are aware that the comment period for the electronic filing rules are coming to a close, I think, this Friday. We've been talking about that on Bar Talk, and we're curious to how you see our electronic filing rolling out in the future too. So the floor is yours.
Thank you, Thad. Thank you to the MSBA and to the leadership for making this forum available again to get the information out, and to Angela for making the whole thing happen. I'll just ask, before we get started, I have some comments I'll make. I'd be happy to address questions. Are the attendees able to send a chat to you, Thad, or you, Angela, they go to Angela? Okay. So Angela receive any comments or questions along the way, and she'll collate them and organize them. And once I get through with these opening thoughts, I'd be happy to turn my attention to those. I'm making a note here to myself to talk about e-filing within my allotted time. I understand we're planning on wrapping up at about 11:30. Is that the plan? Yes, okay.
That's right.
All right, I'll try and go as quickly as I can and prioritize the points. There's a lot to talk about. As I said in my previous gatherings, in order to understand my answers today, I have to give a quick, brief historical perspective. I know you've heard parts of this before, but it really is the predicate for the rest of the things I need to say. You'll all recall the dark days after March 16th when this thing really hit. And we on the judicial branch, we're in full-on crisis mode. We basically locked things down, and we literally were planning from day to day, issuing orders very ad hoc, very quickly. Those orders morphed into PMOs, pandemic management orders, that followed from there. Again, issued on a very quick, very ad hoc basis. We were scheduling on 1 week timetables. On Wednesday, planning for the following week. And then we moved to 2-week increments, planning a whole 2 weeks into the future because of what we knew at those points. And it may seem like a simple matter to simply just go ahead and say, well, say the courts are open from here to here and we'll do this and that, but it really is an unbelievably complex undertaking. Trying to schedule. We have a large staff, we have numerous locations, we have enormous geographic distances and different practices. We have union contracts and other factors, so even internally within the judicial branch, it is a big project. But by about week 9, it occurred to me we've got to get our heads up. We have got to look down the road and fashion a plan for the future so people like you and us can start to plan what they're going to do in the meantime. Desperately needed that. So we embarked on it. It was clear to me that we needed input and information before making those decisions. So we polled our employees, in-house folks, about their concerns and challenges they thought they had. We've consulted with other states, what they're doing in other states. We've also tapped into court management organizations across the country, into national data compilations. And we acquired 2 consultants at the Maine CDC, a public health planner and a medical doctor, to help us make our plan, what we needed to do to bring it to fruition. And as Thad referred to just a moment ago, I convened some stakeholders meetings because I suspected that we didn't really understand all of the challenges and all the insights, and that proved to be true in spades. We heard from innumerable individuals and organizations, and I should add parenthetically that MSBA was well represented and made very articulate and eloquent arguments regarding the challenges. We also received written comments. We had leadership paying attention and taking notes, and we have compiled all of the notes and all of the written comments, and I have almost 200 single-space pages of comments and suggestions, and there's some great stuff in here. I would say there are conservatively 50 or 60 things that people are looking for us to fix, to address, that are uniquely related to the COVID challenges out there. It was incredibly eye-opening. Some of these fixes are relatively easy for us to fix. The domestic violence community advocates pointed out that in some cases, folks who are in danger, living in abusive situations, may be able to sneak out and make it to a courthouse. They typically don't have the resources to know whether those courthouses were operating on reduced hours. They get there and the courthouse is closed and they've exposed themselves to danger. There's a quick fix to that. Keep the courthouses open all day. And we did that. We implemented that immediately, as you referenced. That is, it isn't specifically a response to our summer hours kicking into effect. It was because the domestic violence community said to us, our people need to be able to go to courthouses and find them open. It's challenging because we have to have entry screening at all of those locations. So they're gonna be open all the time. So again, we're scrambling to get folks who will do entry screening for the safety of the folks inside and the people who show up. Other fixes we're gonna take, I think we can do, but it takes a little bit more work. We need to get some input on those. And some of the fixes are quite frankly beyond the scope of what we can do. So we're engaging in a, I guess you would call it triage effort. So while we're trying to manage the whole pandemic crisis, we're also trying to solve the problems. It is a full-time occupation. The stakeholders groups and the other efforts resulted in our phased management plan, which will be our plan from June 1st till September 1st. And I'm sure you've all seen it. I hope you've seen it. It is the key document moving forward for anybody who's involved with the courts. Each step involves certain conditions that must be met before we move to them. It is phased, so when we're in the particular phase, we're looking down the road to what we need to have in place to make the next one start at that time. There's always the possibility, if we don't have it ready, that we may need to react. We always run the danger, if there is a flare-up of the virus, we may need to dial it back. But this is our working plan at the present time. And just briefly, I think you know this, but I need to step through it quickly. First phase, June 1st through June 12th, pretty much the same as the last 2 weeks in May. All case types by video. Priority cases come first. The last 2 weeks in June, June 15th through July 2nd, we have expanded the case types that could be heard in person. There's a list of types of case types that will be processed in person. Our preference, our default still is for remote hearings, but frankly, there are some that can't be done remotely. So for those case types, these can be done in person through July 2nd. July 6th, all case types, except for the 5 individual case types that are stayed, open for in-person hearings. Again, preferences for remote, we'll do that whenever it's possible, but all case types except for those 5 are in. In theory, the door is open to grand jury, not traverse jury, but the question remains whether the various district attorneys and prosecutors can actually get in place all of the necessities for grand jury at that time. But in theory, that's going to take place. Phase 4 is August, when I hope that we're going to be running with all cylinders firing. All case types, including the 5 that we had previously stayed, are able to proceed in person as permitted. Remote, again, is preferred. Grand jury, I hope, will be taking place. Grand jury will probably require some modification of capacity controls. As you know, we set up capacity controls based upon number of folks in the courtrooms and number of folks in common areas by floors. There's a backstory there, but I don't know if you want to go down that road. And then phase 7, doors open for jury trials, starting September 2nd. Now, as I said before, moving to these phases requires that we be ready for them. We have standards, remote proceedings. Right now, we're using Google Meets. I don't like it. I'm starting to think of Google Meet as a toy video conferencing platform. It's a lightweight platform, and we have asked our IT folks to conduct an in-depth study and analysis of all the available video platforms, their capabilities, security, ease of use, and prevention of extraneous interjection of information. So we need to look at our video platforms to make sure that they are robust up to the abilities. We discovered when we wanted to do telephone conferencing that our built-in ShoreTel phones can only handle so many audio conferences, and people tried to call in and got kicked off. So we have done a workaround using the phone-in ability of Google Meets. Unsatisfactory. We need to get all these platforms lined up. A side issue, which may be important to some of you, not others, is access by the public. So when we do a remote proceeding, essentially that's a closed proceeding because you don't get in without an invitation. And the press, quite appropriately so, has said we are entitled to have access. So we're working on that. There's some possible approaches there. Perhaps if they want to attend a conference, they can make a request for invitation, and one of the windows will be for the press to watch your program. The other is, and this is being done in other states, and I kind of like the sound of this, that during a video proceeding, apparently it can be streamed to YouTube live, and when it's over, it doesn't continue to exist on YouTube. Don't know all these answers yet. We're working on them. This is part of the readiness thing I talked about. Scheduling is tricky. When we have in-person scheduling, we have to stagger them. In the past, we had mass dockets, or everyone would appear. They're called in some quarters cattle call dockets. I will not use that term because I don't like it. It's a trailing docket with a large number of people coming in for Violations Bureau. We can't really do that during this crisis. We need to stagger them. And when we look at the backlogs on all of these things, you can do the math yourself. This is the one that keeps me awake at night. As we start addressing our current docket and the backlogs with staggering processes, it doesn't actually reduce the backlog. Things keep building. If anybody has a magical mathematical solution to that situation, please let me know. It is a cause of great insomnia for me. Then finally, jury trials. I know that concept is met in quarters with some degree of excitement. And a number of folks have said, great, how are you going to do them? And the answer is, we don't know. We have 3 months between now and then. And as a realistic matter, probably 2.5 months, because we need to start scheduling them. We need to invent how we're going to do jury trials. They're being done in other states. We're watching those closely. We have a working group within the judicial branch who's working on that. And I would think that they would want to reach out to the private bar for suggestions on how to handle jury trials. So the plan is just that. The plan is a schedule. It gives folks knowledge of what is not going to be done before certain dates. The fact that it can be done after those dates, we've got a lot of planning to do between now and then. Now, a couple of other, I'm going very fast. I'm actually skipping over some things. In order to come into the courthouses, you know, we have a requirement of face coverings and masks, and we don't like the masks. I hate the masks. Everybody hates the masks who use them. It either has to be a mask or a face covering. We went to our consultants at the Maine CDC and asked, are there alternatives to this? And they said, you know, as a practical matter, if you're not in a healthcare setting, face shields offer the same degree of efficacy in controlling the exhalates that we put out. So we have created a change in that rule for our people and for people coming into the courthouses that face shields are permissible. We have ordered 500 face shields for our court personnel. We have face coverings that'll be, face masks that'll be available at the door for folks who show up without them. But in many quarters, the shields have been met with some enthusiasm. They're still in short supply. I did go on the internet and went to YouTube, and there are innumerable YouTubes about how to make your own face shield. Some of them are actually pretty clever. But face shields probably be in our future. That will help folks who have difficulty with claustrophobia or may require some sort of accommodation. In extreme cases, if folks do require an accommodation under the ADA, we have an ADA team right within the judicial branch. Please let us know what your concerns are, and I'm quite sure that an accommodation can be accomplished. The other point is we still receive many requests for clarification. You know, the PMOs are not models of clarity or consistency. And people say, I have this situation, how can I solve it? Particular among those is the 49-day extension rule, which we attempted to clarify, and the questions are still coming in. So here's the deal on that. My first response was that, you know, reasonable people should be able to look at that and say, this is a rule of reason. You and I, meaning two lawyers talking to each other, should be able to look at this and say, this is how we should address it. We don't need the court involvement. And I know all of the members of the MSBA are eminently reasonable, but perhaps you have opponents who are not equally reasonable and have run into problems there. A couple of things about that. I've spoken to Tom Humphrey, Justice Humphrey, who is our representative to the Maine Civil Rules. I said, we're getting very ad hoc questions. I have this case. I have this situation that involves this PMO. This involves this 49-day rule. What should I do? And we should be able to respond to that as a FAQ if it's liable to repeat itself. So what we're working on, it's in progress right now. Hopefully you have it up later this week, is the email address, that COVID comments address is still viable. And, you know, between the scenes back in the kitchen, this is the way it works. Those go to my administrative assistant in Portland, Amanda Martin. She forwards every one of them to me, and I do something like triage with them and ask them to be addressed. So if any of the members have questions about specific applications to cases and they're unable to work it out with their unreasonable opponents, you can write in. Tom Humphrey will collect those, and he will probably try and vet those with the Civil Rules Committee and get back with maybe a specific interpretation. Here's the takeaway from that. The Maine judges will interpret these PMOs as rules of reason. They will not sanction somebody for a good faith mistake in trying to interpret it. I thought this is what it meant. It was a reasonable interpretation. I did this. My clear direction is that no lawyer, no party should suffer a sanction because of a misstep during this COVID period. That is just unacceptable. The trial judges know that. Okay, so I'll just talk briefly about e-filing, the new CMS, the Odyssey program. I talked to our IT folks. Our plan is to have it go live in Region 5, which is Penobscot, and near basically where I'm sitting, in late 2020. And hopefully we'll have our access rules promulgated by then, hopefully have our e-filing rules promulgated by them. They're fresh, hot off the press, as you know, and I'm hoping we're getting lots of comments in on those. We'll work on those through the summer, and those will be in place. If we can't make this work because of COVID complications, we can roll back that date. But as it stands right now, we're still looking at November 2020 for it to go live in Region 5. And to be clear, that is not for everything. That is for a limited subset, mostly civil cases. E-filing will be required by lawyers and other competent filers. Pro se folks or people who have received a waiver on that can still come to the courthouse with a handwritten piece of paper, which the clerk will scan in and enter into the electronic docket. But right now, it's still a plan to go forward. And quite frankly, Region 5 is a test site. It's going to be a shakedown cruise to see how things go. There will be bugs and complications, get things running, and then incrementally it will roll out across the state as we become more and more confident with it. But as of the time it is live in Region 5, any practitioner who wishes to file in Region 5 will be required to comply with the e-filing rules. So I realize I've taken a large degree of my time. I've gone as fast as I possibly can. I've jumped over things, and I would like to open it up to some focused questions if we have any at this point.
Yep. Chief, thank you. And Angela, if you're still compiling there, I can ask a couple for the group. One of the things that you mentioned was the extra things that you're doing as far as like looking into an expanded essential teleconference type capability so that we don't run out of capacity to do teleconferences and so forth. I know that there have been a number of notices recently that I've been receiving for cases. Have you been keeping an eye on the budget for the judicial branch, and do you know if this COVID-19 has caused, at least for this fiscal year, an increase in spending for you?
Yeah, we're watching the budget closely. Seeing what has happened is much easier than predicting what is going to happen. We have, obviously revenues are down across the state. We're holding on. We've actually achieved some cost savings during the COVID downtime, but we are in danger of coming up short. One of the footnotes to this is that the CARES stimulus packages, the financial support things that have gone out to the states, perhaps there is something there for us. I mean, there are limitations on the CARES finances. You can't get money under CARES for things that are previously in your budget. You can't backfill a budget that is coming up short. They're looking for initiatives that are addressing COVID challenges going down the road. Our current video capability, I think, is not up to par. We use the Polycoms and we use just the internet. Not really satisfactory. We've already identified our phone shortcomings. I would love to upgrade and enhance all of the JB audio visual capabilities down the road. And maybe we can get some CARES funding for that. Who knows? Nobody really is sure how those funds will be allocated. The budget thing will hit. I think the discussions will commence in earnest over the summer. It's not clear when and how things are going to take place, but one of the challenges is whether we will have the financial capability to do the things we're looking at. One is just another example. No one has planned juries out yet, but someone floated the idea that jury selection could take place in large venue places, which are not being used. Community opera houses, things like that. We could spread things out, but of course we would have to rent those facilities. That's not budgeted. So I'm taking a long time to tell you, we're looking at the budget in the past. We're okay in the short run, but I think once the statewide budgets run into the downturn in revenues, it's going to be an interesting analysis. And that's all I can tell you at this point.
I notice, thank you. I notice that one of the things that someone's popped up here is, just to confirm, it sounds like what you're looking for are essentially, as far as scheduling and scheduling orders go, is for two attorneys to work it out, maybe send an agreed to revised scheduling order to the court, and that those type of things you're encouraging your judges to sign.
Absolutely. Yeah, I'm once removed from the trial courts, although I meet with the trial court chiefs all of the time. But I think if reasonable attorneys look at a situation that's been caused by COVID, and it runs right afoul of an existing scheduling order, if they were to draft a proposed modified scheduling order, send it to the assigned judge or justice, I'm guessing it will be received favorably. And what I'm talking about here is adjustments based upon the COVID crisis. It isn't the attorneys sort of wrestling control of the case from the judge and creating new provisions that suit the purposes. But if a case can be made and say, hey, listen, during COVID, we had this need to do X, Y, and Z. We couldn't do it. Scheduling order said we had to do it. We have agreed that we're okay with this. Can we go with that? I think that would be terrific. That's exactly what I'm looking for.
And thank you. And just from a practical point of view, I imagine this is going to come up, and I'm curious what position you're going to take on this. Is you've got people that walk in with masks into your court, but then they decide to take them off. What are you instructing your marshals to do when someone's taken off their mask?
We're trying to avoid the marshals seeming like they're being overbearing or unreasonable. So if someone comes in complying and appears to be starting complying, we're first asking them to try and intervene and explain the importance for this. But in the end, non-compliance probably would result in them being ejected, which I think is very sad and very unfortunate. And I just don't like the way it looks or sounds. As for like immediate threats to the people in the area, one of the things that I've skipped over, but I'll mention in passing, is our consultants at CDC told us that plexiglass is a good thing. So we are in the process of getting plexiglass barriers for courtrooms, 3 sides around the witness stand, in front of the judge separated, and perhaps even between lawyer and client. So we're working on that. We're going to try and get it in place before we're doing a lot of these in-person things. Somebody sent me a picture of a New York federal courthouse with plexiglass barriers. It was elegant. I mean, these lovely pedestals with etchings. They looked like Waterford crystal. It's not going to look like that in our main court. We're probably going to go to Home Depot and get rectangles of plexiglass and route out a 2x6 and stick it in there. But if someone is on the witness stand and they were to remove a face mask, it would not present an immediate threat to anybody else in the area. So these are the kind of measures we're taking. The bottom line is we're going to try and encourage everyone to comply with these safety measures.
I have a couple of questions.
Yep.
The first one is the last week still going to be a court admin week? Oh, I'm sorry, of June.
The admin week, the June admin week, has been canceled.
Has been canceled.
Yeah.
Okay.
And that is, again, to make more court time available. We've got we're going to be, as we get more and more in-person hearings, particularly, we're going to be doing a full court press. I am hoping that by August, we have got all cylinders firing. So goodbye admin week. Hello, more court scheduling time.
Okay. And then the other question I received is, do you know if they'll you will be issuing a revision or extension to PMO TC1?
In all likelihood, yes. But I can't predict how or when TC1 will be modified. But yeah, there are some elements to that that require some modification. Yes, something will be coming down the road on that.
Yeah, if you have another one, we'll go at it as soon as you've got it, Angela. So one of the things I wanted to let you know, Your Honor, is that we've been in contact with your communications director. And I've told our MSBA members this, that she's looking to, Amy Quinlan's looking to have us kind of coordinate with her how we can help get the word out about the changes that are going to occur in Penobscot County for the electronic filing rollout. So we are working with her on that, and we're pressing forward. The other thing I wanted to let you know is that we're also working with other constituencies to try to get some proposals for orders for you. We're working on an electronic signature of some sort that is not necessarily, a secure signature, but kind of along the lines of what you put as available, I think, in your PMO SJC 3, that allows us to do some emailing of pleadings. So we're working on giving you some proposals that hopefully can help. We wanted to let you know that.
And that's great. I've got some electronic signature proposals in here, and I would love to add the MSBA's proposal also. It's something that's on our radar. And regarding the rollout in Penobscot County, yeah, Amy's on top of that. And I think the biggest concern is council being uncertain as to how to use e-filing. Is it too complicated? We did have one reach out session earlier to give like an overall picture, and lots of lawyers and lots more office administrators and administrative assistants showed up. Lawyers can use it. It's not rocket science, and if you have a staff that's capable and they've always handled your filings in the past, I don't see a problem. There will be education, which was originally planned to be in person. Maybe it still will be. And there will be plenty of stuff online to walk people through it. So the training thing, I'm hoping, people shouldn't be worrying. It's not going to be a bugaboo down the road.
I don't want to be close on time, but there was one last question. If there is a plan for court-run mediation.
Yes, there have been conversations on that. I am not up on the stage of those conversations, so I will look into it and try and get back to you on to let you know where that stands. But there have been conversations.
Yeah, especially in the realm, Your Honor, of the family cases. You know how there's generally mediation required. Yeah.
Yeah, we have a number of cases that require. Think about small claims. I mean, right. We have a number of cases that require.
But you're putting that off till September, right?
Small claims. August. That was small claims is going to be back up, and as well as the Violations Bureau, which has 2,500 cases backlogged. So we have a lot of solving ahead of us.
Well, we really appreciate the time you gave us, and we hope to be able to have you back on again. We appreciate also that, being a past president of the Maine State Bar Association, that you always are special in our minds for that too. So was there an alibi? I just want to make sure that we aren't cutting you right off, but was there a last message that you wanted to give us before we finish up, Your Honor?
No, I just want to thank you. I think the message is we have a plan, but the plan requires planning and development of resources. We're working on it. We appreciate anything you can give us, and we appreciate the MSBA and the leadership making this forum available to get information out, and Amy will continue to be a great conduit, I think, as information comes out.
Thank you very much, Your Honor.
Thank you.
Angela, was there anything else on the business side we wanted to get out before we closed?
I don't think so. I think we've kept people over. So, I mean, the slide is there. It's pretty self-explanatory. Thank you, Justice Mead.
Thank you. I'll log out of the meeting. Thank you. Bye-bye.
Thank you.
Thank-
Everyone, I just want to make sure you know our next meeting is Monday at 11 o'clock. We are going to weekly meetings to try to get everything together into one meeting per week. Anything that you want addressed, please email Angela or I, and we'll make it a point to get it addressed at the next meeting. We have a special guest scheduled for the 8th too, so we hope to see you then. Bye. Thanks, Angela.